I see they're back on, and recording. Okay. Few people have come back on. I see we're up. And Ken, is the solar discussion the next on the agenda?
Yes, it is. It's the only other item on the agenda.
Okay. We had some questions regarding I guess, the validity of filing a preliminary plan to protect solar panel construction or solar field construction. And what were the other questions?
I had questions around, we have the 8 subdivision applications we had on the agenda last week, 4 of them for projects that have already been granted special permits by the planning board, 4 which have not. And from my perspective and my perspective only, I had a lot of confusion about what the legal process was a developer used to lock in the bylaws that he needs to comply with, grandfathering them, if you will. We had discussions and we talked about 4 different acts that could be the trigger. One was receipt of registered mail at the town clerk's office with the subdivision application. 2 was the planning board or ZBA's acceptance, which was on the agenda last week for the subdivision application. 3 was the planning board or ZBA issuance of a special permit. And 4th was the building commissioner's issuance of a building permit. So it appears to be a confusing situation. Borrego and Zach have told us point blank that it's confusing and that they've seen things happen that they don't understand. So I thought it was important before we acted on any acceptance last week that we understand this well. Or as well as we can.
Past practice has been we start the clock when a complete application is submitted to the planning board. That way, a plan can be submitted, be reviewed for its thoroughness, and corrected before it gets in front of us. I know that there's a procedure to send them or file them with the town clerk. And it's always been thought that that keeps the clock running, starts the clock running. And it's been used by developers to try to take advantage of a situation where we don't have planning board meetings for 6 weeks or so.
So George, that's a 5th triggering event in my mind.
I don't know if it's in the rules and regs. I think it is in the rules and regs that, you know, a plan is submitted and we didn't start the clock until it was submitted to the planning board.
Well, it's not so much starting the clock, it's putting a stake in the ground as to which bylaws apply, old or new.
Well, once you start the clock on an application, that's one thing. That's separate and apart from what you can do if there's a zoning change. Now, Borrego represented that even though they have a special permit in hand and a site plan approval, that should the bylaw that's on the warrant be successful, they would not be able to build. I think we've always been of the belief that once you just submit a plan, you've locked in the uses for a period of time, whether you go to the a definitive plan and get an 8-year freeze, or you let it expire in 8 months and not go for the preliminary. What the Zach from Borrego told us was that did not freeze the construction of the solar field. Did not, the actual construction was subject to a building code, which building permit, which we were all kind of, well, I was kind of shocked by because we thought that gave them a freeze on all aspects of zoning.
Mm. I have a feeling that I'll probably be reporting back to you on next Monday night on this as well. But I can give you my preliminary thoughts on it if you'd like them.
Certainly.
I think the only way, well, subject to, and one of the members was kind enough to supply me with some good details, but subject to getting more information. This is kind of where I lean on it. If we've got 3 or 4 with special permit, and I think the only way that they're going to lock themselves in is if they get a building permit. I think that's going to be the only lock for them. Now, they may have their own business reasons for not doing so, but their business reasons aren't necessarily the reasons why they do or don't get protection. So my preliminary take, for example, on the Borrego thing is they want locked in, go down and get a building permit. On the other ones, really, I think the only way they get any kind of protection is get a permanent subdivision plan in place. I think otherwise they're just out of luck.
Say that last part again, to get a special permit in place?
Well, yeah, I suppose you could do that. You
well,
can get a special permit in place and then get your building permit if you can get that done before. But I think, people who are just coming in the door now are going to be swimming against the tide.
Well, they obviously think that they're locking themselves in by executing now.
Well, why don't we have them tell us why they think that's so? Because I'm not sure that it is.
So, Attorney Bone, on our agenda last week was planning board acceptance of 8 different subdivision applications. And we have 45 days, I believe, to do that. Starting from, and that was another question, but starting from either last Monday or from when the applications were received via registered letter at the town clerk's office. It was my thought that if I have 45 days, I don't want to touch these things till after town meeting.
Who you personally don't want to touch them?
I don't want the planning board to vote to accept until after town meeting.
Well, the applications are in.
Go ahead. I'm sorry.
The applications are in. I would just process them in the ordinary course.
Why?
Do you have a bylaw in place that prevents you from doing that?
I've always been of the opinion that just filing the plan locks them in.
All right.
I don't know if that's accurate or not. Maybe you could.
Well, it sounds like something to be explored.
I'm really surprised that this isn't, and forgive my naivete, but this isn't common knowledge with the Mass General laws. I mean, obviously we don't know about it. It's now I'm learning that it is a very ambiguous question.
Yeah.
Well, I don't mean locks them in forever. I mean, they have to file a definitive within, is it 8 months or something?
8 months. Yep.
But number one, what would a denial do for them? By a denial by the board for these projects that haven't even been in front of us, where does that leave us?
Well, it leaves them taking an appeal and arguing to the court that they should have been accepted, that you should have acted on them or approved them, and that they're entitled to some sort of protection.
Now, Mike Baptiste, we used to just let preliminaries die on the vine. Do you remember that?
Did
You remember the reason for that? Was that just to not make statements that could come back to haunt you in the definitive?
we went through that process with the freeze plans move probably about 10 years ago.
Mm-hmm.
Yep.
I mean, we looked at them and critiqued them, but we never voted on them.
No.
Wouldn't trying to review and approve 8 sets of plans in such a short period of time, doesn't that sound a little bit unrealistic?
Well, that's part of the problem is they don't have, it's doubtful that the previously approved ones could get a building permit in that period of time.
Right, much less the ones that we haven't even seen yet.
Right. So their attorney is going to say it's unrealistic. So, it becomes a moot issue.
Why did we put, eight plans on one agenda for last Monday was unreasonable to begin with. As soon as I looked at that agenda, I said, what are we doing to ourselves? This is a 2 o'clock in the morning meeting in the making.
Well, that, as far as I know, that does 2 things. Just filing the plan puts them in the zoning in place at the time. That's what my understanding's always been.
One of the big things, George, remember back before was the question was whether it was at the planning board's desk or stamped in by the town clerk. Because we had stuff in the past. Town clerk leaves 4:30, 4:25. It was stamped in. Boom, the clock starts. We don't have a meeting for another 2 weeks.
Well, that's what I mentioned earlier was, I think we put it in our rules and regs that the clock starts when it's on the first meeting it's submitted to the planning board.
George, that's actually in the rules and regs?
I believe so.
Okay.
That's correct. It gives 2 options in the rules and regulations. It has one for filing at a regular meeting of the planning board, and the other is for mailing it by registered mail to the town clerk.
Or in person. Or once they stamp
in the regulations.
Yep.
And the reason for that rule was, some proponents would wait for a month when there was maybe a holiday and a town meeting and we weren't meeting for 6 weeks, and that would slide right by. And so I don't know which one is correct.
All right. Well, let me take a look at it.
Well, that's the time clock. That's when your 45 days starts. Now, if filing a preliminary plan locks in your zoning for 8 months, then there's very little action has to be taken on the preliminaries other than pointing out to the applicant what deficiencies you see.
Yeah, is it complete?
Yeah, if it was incomplete, I don't know if you bounce it back to them, does the clock start over?
Yeah, you just throw it out and say, look, it's incomplete. Until it's complete, the clock doesn't start. How can it?
Yeah, correct.
Okay, so what else have we got on this? Just so I can have a more complete understanding of what you've got here. It just all comes down to the basic question of who's going to get protected and who isn't.
Well, a discussion was had with Borrego, and I don't know if anybody else, he kind of gave a broad-based request that we grandfather these permits that have already been approved.
On what basis?
On the basis that they
had a special permit. They had a special permit in hand.
Yeah, prior to even the printing of this bylaw.
All right, I'll call, what is it, Zach
Yeah.
Is he the one who was making this argument?
Yeah.
Okay.
I can't think of his last name.
Frakes.
Yeah,
I don't want to characterize it as an argument. He had made a request to the planning board at the time we were making our vote on support or non-support of the citizens petition solar bylaw article, that if we would state in the motion to make the comment that, and anybody with a special permit that this board felt should be grandfathered under the current bylaws. The point I made to him is that this board was just making a recommendation to town meeting vote, and anything we had to do about terms and conditions around that were not enforceable in any manner, shape, or form.
Yeah, I agree with what you're saying there, because look, the question of whether they're going to have protection is a matter of law. It's not a matter of opinion. And expressions of opinion as to whether it's grandfathered made by the planning board to town meeting are just statements of opinion. They're not binding on anyone, and are, and I say this with the greatest of respect, potentially misleading. So I wouldn't do what he's asking, but I'll talk to him. I'll see what he's getting at here.
Well,
Yeah,
I think any such grandfathering would have to be done in the form of an amendment and approved by the body. I don't think anybody else can make that guarantee.
Yeah, I agree with that too, Mr. Chairman. I think, you have the scope of the article question, which, I'd have to think about. And of course, it's up to the moderator as to whether an amendment is within the scope. It's not up to me or any of us.
Well, I just think that has to be the process. You can't add it on.
But George, with that disclaimer, yeah, I think you're right. If somebody wanted to make a motion to carve out from the bylaw certain projects that are already in the works, I think that's legitimate if that's what somebody wants to do. Whether people want to vote for it or not, that's a different question, of course.
Mm-hmm. Did you have something, Richard?
No, I think Attorney Bowen understands the question that we have. I do not want to act on the acceptance of those preliminary applications until we have a better understanding and have a chance to know what we're doing, especially considering that we have the time to do it. We have the time to wait, and we're not under a rush. And to back up a little bit, it was my impression that all we were voting on was accepting the plan, which was a time marker more than anything else. It wasn't reviewing the plans or going through the actual design concept. It was just accepting the fact that they'd made an application. Maybe I'm wrong on that.
Yeah, that's right.
Well, we know that the 4 that are already approved must have been reviewed for completeness and the like. The new 4, we could be taking the time to do that, but I think since some of those are from past performers, this would also affect the Rocky Maple thing, or maybe
yes,
maybe not, because it more. I don't know. I was going to say it does meet the bylaw, but it doesn't meet the 10-acre thing.
George, if you have some thoughts on what our past practice has been on this, if you could email them to me, that would be great, because I would like to take a look at that.
Okay.
All right. Now this has been very helpful to me, and hopefully I can be helpful to you on Monday. Yeah. Okay. I think I have a good idea on this.
Okay. Thank you very much, Attorney Bowen.
No, I enjoy meeting with you.
You better when we go.
On a rank, isn't it?
Thanks for your time.
Well, anytime. I'm glad I don't have to wear a tie. I especially like that.
I got ties. I can wear a tie when we go to court too.
Oh, hey, I know. I've seen you in action.
I'd pay money for a ticket for that.
I'm a reasonable.
He's a good witness. I can tell you that. All right. I'll be talking to you during the week, I'm sure.
All right.
Thank you.
Thanks a lot. Talk to you soon.
Well, I guess that, whoops, where'd everybody go?
Oh, we're all still here.
There you are. I think that concludes our agenda.
That's right.
So,
Did you have something for 48-hour business you wanted to do tonight, Ken?
oh yeah,
There was Master Millworks. There was a complaint from Charlie Rowley about an inspection he did, but I've gotten new information from the Master Millworks, and so we have to go over that. Probably pick that up next Monday's meeting.
Okay.
We're going to talk about a lot of things next Monday, I think, Ken, because I'm really disappointed with the input we had from Dave. Who's he working for? Us or the proponents? You know, last year we went through all this garbage. We wanted to tighten up the bylaws and the rules and regs so he can go to court, a slam dunk, no bullshit. We got this guy over here, you know, messing around with us for the last 10 years, does exactly what he wants. And of course he turns 180 degrees. What is he, a blade of grass politician?
He was going on the decision that he was asked to enforce, and his opinion was it wasn't written.
Well, we don't have to agree.
I want to remind you, guys, you're discussing issues that were in executive session, in open session now, and you can't.
I can't wait till we get back to meetings face to face because these computers are a pain in the neck.
I agree. Anyways, I'm hopeful that the situation at Master Millworks has been resolved, and
I'll report next Monday.
very good.
Motion to adjourn, Mr. Chairman?
Second.
Sure, it's only 7:30, you know. You're not hungry, are you?
Oh, I already ate.
Motion's been made and seconded. All in favor? Richard?
Aye.
Sam?
Aye.
Mike King?
Aye.
Mike Baptiste?
Aye.
And aye for the chair. Thank you, gentlemen.
Good
Good
night.
meeting. Thank you.
Good night.